And he's living in Mia's house and renting it from Mia. Mia's saying, yeah, thanks a lot with Joe Baloney. And with that lease, and if you have to break the lease because of non-payment of rent, or they have a business going, or they have animals, whatever it is, could that renter or rentee take the owner to court saying that they are breaching that contract?
No, ma'am, because that being said, their response usually only comes into play after they've received, their notice. And then if they do nothing in keeping with the notice, then the landlord will generally file what's called an unlawful detainer. The unlawful detainer is the instrument that will eventually provide, the landlord with a court order to remove the tenant. Once the tenant is served with the unlawful detainer, they have 5 days to be able to respond to it, to set forth their position, why it is that they believe they should be able to stay, why they haven't breached the contract, and then, everybody has a voice in that matter.
Mm-hmm.
Following that, if in fact, again, there's a trial involved, the court's going to decide who has, the authentic, breach and who has the rights to either remain or be evicted. A duration lease, a year-long lease, something of that nature, the language in the lease is going to give everybody knowledge about what their rights are. And, again, landlords are of the mind that, again, this is a business relationship. Everybody's on the same page. And if you breach my lease, I have rights and I'm going to enforce them.
Mm-hmm.
Tenants then at that point in time are in a position to where they either have a very good defense or they're calling the U-Haul.
Yeah. Okay. And, Bob, what is your point being on the real estate side?
Hey, Thomas, how you doing?
I'm good, Bob.
Good. I just had a quick question. Also, the term of the lease determines what the notice is that you have to give somebody, whether it's 30 or 62, isn't it?
You're absolutely right. If you're dealing with a duration lease, then they're going to have language specifically to that point. If you have a month-to-month lease, well, then both parties are generally at their will as to when they give notice, and that's usually a 30-day notice.
Now, also,
so if I've got,
go ahead.
Go ahead.
I was going to say also, now, if it's somebody, for example, that is in a property that they're being evicted, and they're a renter. I'm sorry, they're a renter, and the property they're living in is being foreclosed upon. What is the term of the duration that they're allowed to stay in the property after the eviction is over? If they have say they got a year's lease or something, but the property just went back to the bank.
That's a good question.
Well, the bank, if they are dealing with a renter, they would be in a position to where they have to give that either knowing or unknowing tenant 90 days to be able to vacate the property. The assumption is that the former owner of the foreclosed property didn't give proper notice to the tenant, and therefore they're at a loss. They're going to be displaced.
Right.
So the court's going to allow them at least 90 days to be able to, remove themselves. The bank would be entitled to, fair rental value for that place. And again, if that's not paid, well then, okay, the bank has remedies. But at the end of the day, if in fact that property is foreclosed on, up until the time that property is foreclosed on, the owner still has all rights and privileges. If they have a lease with these people, and if the tenant were to find out that the property is being foreclosed on and say, hey, I'm not going to pay rent, you're going to let this property go back. Yeah, that doesn't work. I will get calls from renters all the time saying, hey, they just posted this foreclosure, what does this mean? And I'll say, well, you're moving.
Yes. Get ready.
And they'll say, well, wait a minute, I've got a year lease with this guy, and I've been paying him regularly. And I'll say, well, that's what you should be doing. You have a lease with this guy. And then they'll say to me, well, wait a minute, this guy's not paying the mortgage. And I'll say, well, it's his money. He can do with it what he wishes. And then they'll say, well, wait a minute, and I'll have to go around in circles with these guys a little bit. It's an unfortunate situation, that phone call. It really is.
And also, Bob, Barbara, and Thomas, since, we're doing the good, the bad, and the ugly, now let's bring up a bit about all the banks, like B of A, Wells Fargo, all of them. And they're getting nailed left and right. Countrywide. Yes, them are one of the worst.
Rest in peace.
Yes, they're getting bombarded from the government because of all their wheeling and dealings and messing around with everybody. Now, if you have a house and you are going to one of these banks, all right, the bank shuts it on down. They're done. They're closed. You can't get your money in. You can't get your money out. You can't do nothing. And the owner has this property, and the owner has to sell this property to regroup what he just lost.
Right.
Now, and you have to have this poor family removed, and it was beyond everybody's control. What happens then? Thomas, do they still have to go through the same procedure on the 3, the 30, or the 60? And then, Bob, what happens on the real estate end?
Well, I would say that more than anything else, the tenant has rights. I mean, they do. If they're paying their rent and things of that nature and the unfortunate landlord is having issues with the property, well, everybody has to remember that that tenant's there and they're current. So if there's going to be a change of title on the property, whether the landlord's going to let it go back through a foreclosure, or maybe Bob can talk about a short sale situation as well.
Mm-hmm.
Everybody has to understand that if that property is going to change hands, whether it go back to the bank or otherwise, that tenant remains with rights. They're limited, but at the end of the day, if that property is sold, it's sold subject to that lease, and if it's foreclosed on, then the bank understands they have to cut that guy a little bit of slack in order for him to, again, find new digs.
Mm-hmm.
No, and isn't that happening too? I'll have a customer call and go, I'm buying a duplex. There's 2 current renters. Me and my family are moving in. We have to get them out. Again, if I'm hearing you correctly, they still need to, inform them, hey, we're getting ready to buy. We're going to give you the 30, 60, 90 days, right?
Well, I would put it to you this way. If the tenant is on a month-to-month, that's totally okay. They'll give them 30 days notice and say, listen, it's no disrespect to you, but my lease allows me to give you 30 days notice and have you go. So that's what I'm doing.
Right.
But if that tenant has a long-term lease, then that property is going to be moving subject to that lease. If somebody's going to buy that property,
right,
one of the sell points would be, hey, listen, I've already got a renter in place. He's going to be there for the next year.
Oh,
really?
My gosh.
Okay.
Well, also what happens as an example, if there is a lease in place, when you buy the property, you buy the lease along with it, and you're obligated to continue to allow those people to live there under the terms and for the term of that particular lease. So,
yeah, that's correct.
Now, recently I had a situation where we put the house on the market, and the left hand didn't know what the right hand was doing. The owner had a property management company who put a renter in there when he told him, don't do it because I'm gonna sell the property. And so what we had to do is we had to negotiate with the tenant who had just moved in 3 months ago to buy him out of the lease, so that when my client, the buyer bought the property, they would be able to take possession of the property for themselves rather than having to wait the duration of that particular lease.
No kidding.
Yeah, if that tenant refused to be bought out, then I would suggest that again, that property can change hands. They're just changing hands with a new tenant.
Yep. Wow. Well, there's even different contracts. One with when the house has a tenant in it when you're selling it, or it's in foreclosure, and one when they're not, so that all parties involved are all noticed as to exactly what the situation and circumstances are.
Well, what happens, I want to ask all of you all, okay? What happens if you inherit a house? God forbid grandma and grandpa or mom and dad or auntie and uncle, whomever, passed away, and in the will you inherited this house. Now, and they are, the house is paid for. All right, let's use that as number one. It's paid for, but you have these tenants, and you want to get them tenants out. Now, is there a time frame that one has to wait when they do inherit the house before they can start removing the people that are in there, or can they just go in there like gangbusters?
Again, it would depend on the lease, right, Thomas?
Yes, sir.
That's what I'm hearing you say.
If it's month to month, then you give them 30 days notice. If they have another 6 months left on their lease, then you're basically locked in unless you can negotiate a buyout from them.
Okay, I was just wondering, because we're talking about buying and selling, and then the thing about having it inherited, it came up. I thought maybe there was a little loophole there somewhere.
But it sounds completely different. Go ahead.
Here's what the loophole is. If the property is in somebody else's name, grandma's name.
Right.
Well, then the heirs or the beneficiary, the people who the house is going to be, flowing to, they first have to take steps to be able to make sure that they secure a proper title. They'll have to make sure that their names are put on and grandmas are released, and then they have what we call standing. They now become the owner, and then they are free to deal with the tenant as be.
Now, as far as the standing goes, that's kind of complicated. I have a client whose grandmother died. They have tenants in the property. The property in her will is designated to go to the two brothers. However, since it hasn't been probated and it wasn't in joint tenancy, they now have to go through probate to get the property in their legal name before they can do anything further with the property.
Ooh, that wicked word, probate.
Yes.
Isn't that nasty?
Well, you got to either have a trust or have it in joint tenancy or tenants in common or something, so that when the person dies, it can flow directly to them without the delay and cost of probate. Is that correct, Thomas?
Yeah, Bob's doing a commercial for me right now.
You can pay him later.
And he's doing so good.
Well, trusts are
Bob,
great.
what did you just say?
I said trusts are great. It's one way that you can avoid a lot of those headaches and a lot of that cost for a nominal amount.
And
it's really true. The trust is an instrument that allows you to do some pre-planning into, prior to any unfortunate occurrence. It allows you to put your affairs in place, and the will that goes along with your trust becomes the directions. And so once titles are transferred to the estate, probate becomes less of an issue, and the executors of the will and the trust, they just go to work.
And you can also include cash and stocks and bonds and cars, and anything in that trust that you want to designate where it's going to go and how it's going to be, what the disposition of it's going to be at the end.
Well, and
yeah, that's absolutely
proceeds
correct.
And everything. Mm-hmm. Yeah.
Hey,
of course, there are different. There are different types of trusts. And again, if you're looking for something that's flexible, you're looking for a revocable, a life trust. If you're looking for something that's hardened and very black and white, you're looking for the irrevocable.
A quick question here. In our economy now, what are the most types of legal issues coming up now that you're being asked about to adjudicate? In
dealing with economic issues?
Mm-hmm.
Man, it's kind of twofold. Mr. Ewanishyk's office, we do an incredible amount of bankruptcies. It's an unfortunate truth, but we do. A lot of folks are looking for protection in hard economic times, and so bankruptcy allows them to put their financial affairs into place. We deal with a lot of real estate deals because, again, deals are going bad. There were markets that have fluctuated, and therefore deals have just gone bad and positions change. It's an unfortunate reality in dealing with bankruptcies, but I want, your listeners to understand that there is always going to be options. Don't think that for a moment that the creditors carry all the cards. You're always going to be able to seek some sort of protection. And oftentimes I'll deal with folks and they'll say things like, man, I never thought I would do this. And I would say, well, these are options. It's not a have to. There just may be options you want to consider.
Now, you mentioned bankruptcy. I ran into an interesting situation a couple nights ago. Spoke with a lady who lost her house 2 years ago. She filed a bankruptcy. The house was behind. She did the bankruptcy, assumed the house was gone. Last month, she gets a notice that the bank just filed a notice of default on the property. And she's like, well, I thought the property was discharged in the bankruptcy. And was it just the debt that was discharged? And she's still on title for the house?
Well, what generally happens is, in a bankruptcy, what you do is you state your intentions towards the property. I'm going to keep it, I'm going to give it back.
That's called reaffirming, right?
Yeah, if you keep it, if you reaffirm the debt, then you maintain payments and everything is business as usual.